1.2-298.01. Provision B of the sentencing guidelines. Whereas its law states that the court shall file with the sentencing guidelines records of the case a written explanation of departure, whether it's greater or less. Whereas Virginia Sentencing Commission annual report from fiscal year 2007 to 2013, that showed no written reason for departure provided by judges in more than 3,000 cases, in which all the sentences imposed exceeded the guidelines recommendation. A clear violation of the law, the word shall, stated in provision B. We can only imagine the statistics for earlier years such as 2007, earlier than 2007, and since 2013. HB 2087 Provision B amendment serves to hold our courts accountable. It will achieve consistency, fairness, and make Virginia's truth in sentencing transparent and serve the very purpose for which it was enacted. I seek to report back to your constituents that HB 2087 will return back to full committee to be addressed at that time. I ask that you vote in favor of this bill, and thank you so much for allowing me to speak.
Ma'am, thank you. Anybody have any questions for the speaker? Okay. Any other member of the public like to be heard? Oh yes. I'm sorry, ma'am. I apologize. I thought you were with her. Please step on up. Tell us your thoughts.
Good afternoon. We'd like to thank to the subcommittee and Delegate Herring for hosting this bill for us. RIHD, my name is Brenda Jefferson, and I'm with RIHD also. RIHD has been working on this sentencing reform since 2009. And the RIHD supports Delegate Herring of the sentencing guidelines to reflect the failure to follow any and all the provisions of this section, or the failure to follow any and all of the provisions of this section in the prescribed manner, or the failure to impose sentences within the range recommended by the sentencing guidelines shall be viewable on appeal of the guidelines to allow offenders to appeal. According to the Virginia Criminal Sentencing Commission's annual reports, and they are from 2007 to 2013, no written reason for departure was provided by judges in more than 3,000 cases in which sentences were imposed that exceeded the guidelines recommendations. Thus, it is unclear whether the departure of those cases were due to factors like race, religion, sexual orientation, economic status, or other considerations that would not play a role in the sentencing decisions. We ask that you fix these guideline disparities. Thank you for your time.
Thank you, ma'am. Anybody have any questions for the speaker? Thank you. So, we're having just some chatter back and forth about, obviously this new language is arguably restating, and we're just when we have the Supreme Court's here and the Sentencing Commission is here. Meredith, if you could maybe step up for just a second. So what the lady's saying is that we get an awful lot of these where we still don't get, we get a blank, and we're supposed to get some information when they depart either direction, right? Up or down?
Yes.
Okay. Give us some idea of the quantity. Just 3,000 is a huge number unless there's 3 million, and I don't know how many of these there are.
Sure. Well, for fiscal 16, the most recent year, we had 599 sentencing guidelines forms come to us with no written reason provided. That's out of 23,041 felony sentencing events in that fiscal year.
Yeah, those are that were out of the guidelines.
Correct.
Were the 23,000 out of the guidelines?
No, that's the total number of felony sentencing events in a year.
So 80% of them are within guidelines, so ballpark 5,000. Okay. We have the Supreme Court's here. We fuss at the judges.
Can I ask?
Delegate Gilbert.
Before Meredith leaves. So you all publish the degree to which a judge conforms to the guidelines, either below, above, or within. Why couldn't you create a separate category of how often or what percentage of deviations include an appropriate explanation so that we can keep track of that just the same.
Well, in fact, at the request of Delegate Alba, we did expand the report that we provide to the Courts of Justice committees each year for judges coming up for reappointment. So this year's report did include a column for each judge up for reappointment that indicated the percentage of missing departure reasons, cases with missing departure reasons. So we have done that. We do try and emphasize with the judges during their pre-bench orientation and at judicial conferences how important the departure reasons are. And one of the things I just wanted to point out that back in fiscal 12, of all the felony sentencing events, 4.2% didn't have a reason when one should have been provided. That percentage has been going down each year since. So in fiscal 2016, it was 2.6% of all the felony sentencing events didn't have a reason when they should have. So we think we're making a dent in this and that we're working with the judges and continuing to emphasize the importance of it with the judges, and we think it's improving, and we're committed to continue to do that.
And I missed the day where the judges came up for interview for reappointment, so I don't know if that came up during the questioning of those sitting judges, but I do recall somebody wrote a letter to the judges about deferring and dismissing cases at one point, and that seemed to create a buzz within the judge community about being more vigilant about only doing that when when they have statutory authority to do that. So I wonder if
let me ask you about this.
Well, wait, I'm wondering if you or Dave wrote a letter. Okay, you knew where I was going with that.
I sit next to you about 10 hours a day.
I know, but everybody else.
What Delegate Gilbert is about to say. When you say that we started scoring this, I think all of us here believe the thing that, what gets studied gets done, or whatever expression, that what's measured gets done. Do the judges know we're now keeping an eye on this?
We had brought it up at the most recent judicial conference back in May. We plan to continue to bring it up at the judicial conferences. In addition, I had sent a letter to Chairman Alba, and I believe I CC'd Delegate Herring on that, where it's the Commission's intent to send a letter to all the circuit court judges in the next month or so, reminding them of their duty to provide reasons for departure whenever they sentence outside of the guidelines range, and in addition provide each judge with his or her own percentage of cases missing departure reasons. So that is a communication that will go out from the Commission in the next month or so to all circuit court judges.
When you say that there are 599, is it evenly spread, everybody makes mistakes, or do you have a couple of, like when we looked at the sentencing guidelines, we found some where everybody's mostly the same, and you have some real high sentencers and some low sentencers. It's not evenly distributed.
It is not. There are some judges that simply, by the way they handle their cases in the courtroom, they hand it off to their clerk and they overlook providing the reason, and the clerk doesn't give it back to them to provide that reason, and it instead just gets sent to the Commission. So we've tried to emphasize, I know of at least a couple of judges that have changed the way they're going to handle that.
Mr. Chair.
Delegate Gilbert.
So, ladies, I think we are sympathetic to the notion that when we tell the judges they're supposed to explain these things, that they're supposed to explain these things, and regardless of the fact that they hand it off to their clerk or not, that's not acceptable. So, well, okay. So I'm just telling you, like, this, to me, your bill may create some potential problems that we don't want to create, but I think we've had some effective communications with the judges before about other issues where we thought they were doing something wrong, and maybe a letter from our chairman to the judges or some other way to communicate, not just that the Sentencing Commission is interested in this, but that the body that evaluates their work as they choose to come back for reappointment as judges is also interested in them doing their job as we've told them to do. So I would suggest that is probably an effective way that we can get to the same place. And it sounds like they're already making progress without maybe creating some other problems with this legislation. So I just wanted to tell you we are not unsympathetic, and we hear you loud and clear, and we're just as offended as you are that judges ignore their mandate, their legal mandate. And we would like to help you fix that, but maybe not this way is all I'm saying.
Is that a motion?
So I move to lay the bill gently on the table with we request of the Uber chair that he find a way to communicate this on behalf of the House Courts Committee to the circuit judges of the Commonwealth.
Okay.
Yes.
I would just add, Eileen Smith with OES at the Supreme Court. We did have a session at the Circuit Court Judges Conference in May where Ms. Jody Fridley, I think, with the Sentencing Commission was part of a panel. And I would also say that in the JPE panel where Delegate Alba was involved, he specifically mentioned to the judges that the number of times that they don't give an explanation was part of a report.
That's
and
good. So the chairman got to convey that personally on behalf of the
compliance rate, I think, was how he phrased it.
Okay.
But he did. I mean, I was there, and.
But y'all are keeping track of it, Meredith?
Yes, sir.
Okay.
The other thing I would just add that Meredith said some judges who maybe weren't as good at this seem to have been changing their procedures, and so hopefully it will continue to get even better.
All right, so let's go ahead and, the motion was made to table, we then kind of broke procedure and talk some more. All right, all in favor of the motion table signify by saying aye. Aye. Opposed? Is there, I said no.
Yes,
No.
I'm sorry? I did.
Okay.
No.
We would like a letter from the chairman to say that we will be looking at these issues, and they will be entered, that they're scoring it, and they will provide it to us, and this will be something they can expect questions on when they come back for hearing. All right, so everybody, we have just what we call lost quorum, which means people have enough other commitments they're going to have to go. So we really can't take up any work until we have quorum. I think it's best just to call it a day. We're going to find people. Okay. All right, so everybody, so we're going to adjourn today. The only bills we didn't get to were member bills, which just means it's more work for us, but it's not. Is there any witnesses here for any bills we didn't hear today? Okay. All right. All right, we are adjourned. Okay. I'm glad they have this.
Make sure remember
Yes.
I gotta run